Hello contract enthusiasts, welcome back to Growth, mid-sized company, where we decode the intricate world of FIDIC contracts. Today, we'll explore a series of essential clauses, starting with Clause 1.1.6.1 Contractors Documents. We'll then delve into other key definitions that shape construction contracts. Buckle up as we unravel the legalities, obligations, and practical insights of this vital clause. Let's get started. Contractors' documents sounds technical, right? But what exactly are they? In the FIDIC Yellow Book, these are the documents the contractor must submit to the engineer, as specified in the contract. But there's more to it. Let's explore. First, content and language. These documents include technical specifications, regulatory approvals, and more, all written in the language defined in the contract. Next, preparation and inspection. The contractor prepares these documents, and guess what? The employer's personnel can inspect them. Then, copyright and usage. The contractor retains copyright, but the employer gets a special license to use them. And finally, submission procedures. How and what to submit? The employer's requirements have all the answers. Now, let's talk real-world implications. From clarity and compliance to intellectual property rights, this clause has it all. Coordination with the engineer is key, and understanding your rights and obligations can save the day. And there you have it, Clause 1.1.6.1, demystified? Whether you're a contractor, engineer, or just curious, understanding this clause is a game changer. If you found this video helpful, don't forget to like, share, and subscribe for more FIDIC insights. Now let's move on to next clause.
Moving on to clause that might seem simple but holds profound implications for any project. It's Clause 1.1.6.2, country. Let's get started. So, what does country mean in the context of the FIDIC Yellow Book? It's not just a place on the map, it's a concept that encapsulates the legal, cultural, economic, and environmental aspects of the project's location. Let's break it down. Legal framework. The country sets the stage for the laws, regulations, and standards governing the contract. Cultural considerations. From language to local customs, understanding the country helps in building relationships and smooth project execution. Economic factors. Currency, taxation, and economic stability are all tied to the country. Environmental regulations. Adhering to the country's environmental laws is crucial. Now, let's look at a real-world scenario. Imagine an infrastructure project in a developing country. The contractor faced challenges due to unfamiliarity with local labor laws and environmental regulations. A deep understanding of the country clause could have guided them through these complexities. Oh, next time you come across the term country in a FIDIC contract, remember, it's not just about geography. It's about understanding the multifaceted aspects that can impact your project's success. That's it for today's episode on Clause 1.1.6.2, country. If you found this video helpful, don't forget to hit the like button and subscribe for more insights into the world of FIDIC contracts. Now let's move on to next clause.
Moving on to Clause 1.1.6.3, the employer's equipment. Grab your notebooks, and let's dive right in. Employer's equipment refers to the apparatus, machinery, and vehicles made available by the employer for the contractor's use in executing the works, as stated in the employer's requirements. Interestingly, it does not include plant that hasn't been taken over by the employer. The essence of this clause is to delineate the equipment provided by the employer for the execution of the works. It sets crystal clear boundaries on what constitutes employer's equipment and what doesn't, thereby averting potential disputes or misunderstandings during the project's execution. The stakes are high with this clause. The contractor bears the responsibility for the proper use and upkeep of the employer's equipment. Misuse or failure to maintain can lead to the contractor being held accountable for damages or losses. Simultaneously, the employer must ensure that the specified equipment is in a condition apt for the execution of the works. When navigating this clause, it's vital to ensure that the employer's requirements unambiguously specify the equipment to be provided. The contractor must be fully aware of their responsibilities concerning the use and maintenance of the equipment. Additionally, the implications of using the employer's equipment on insurance and liability coverage should be considered. Let's delve into some case studies. In one instance, a contractor using the employer's heavy machinery faced a breakdown due to normal wear and tear. Guess what? The employer, not the contractor, was held responsible for the repair costs, all thanks to the employer's equipment clause. In another scenario, a contractor who used the employer's equipment for tasks not specified in the employer's requirements ended up damaging the equipment. The contractor was held liable as they had strayed from the agreed terms. These examples underscore the paramount importance of understanding and adhering to the employer's equipment clause. It's a two-way street where both the employer and the contractor must clearly define and comprehend their respective responsibilities regarding the use and maintenance of the employer's equipment. It's not just about tools and machinery, it's about collaboration, understanding, and foresight. So, whether you're an employer or a contractor, make sure to dig deep into this clause and align your actions accordingly. Stay tuned for more insights, and don't forget to hit the like and subscribe button for more engaging content on FIDIC contracts. Now let's move on to next clause.
Moving on to Clause 1.1.6.4, Force Majeure, a vital and often complex aspect of contract management. Let's unravel its intricacies together. Force majeure is more than just a legal term, it's a lifeline in unforeseen circumstances. In FIDIC contracts, it's encapsulated in Clause 1.1.6.4, and here's what it entails. Definition includes natural disasters, war, strikes, and other unforeseeable events. Notice of force majeure, under Clause 19.2, requires the affected party to give notice within 14 days, specifying the obligations that will be prevented. It doesn't apply to payment obligations. Duty to minimize delay, under Clause 19.3, mandates both parties to minimize any delay due to force majeure. Consequences of force majeure, under Clause 19.4, may entitle the contractor to an extension of time or payment of costs. Optional termination, payment, and release, under Clause 19.6, allows either party to give notice of termination under specific conditions. Understanding force majeure is best done through real-world examples. Let's explore some intriguing cases. In Nepal, the 2015 earthquake led to an extension of time, reflecting Clause 1.1.6.4. Contractors invoked force majeure during the Arab Spring, aligning with FIDIC guidelines. The global pandemic, COVID-19, has led to numerous force majeure claims, referring to FIDIC's guidance. The world is changing, and so is the interpretation of force majeure. Here's what's on the horizon. Force majeure clauses are evolving to include extreme weather events due to climate change. The inclusion of cyber attacks as a force majeure event is becoming more common. Force majeure is not just about legal jargon, it's about understanding, preparedness, and responsiveness. Here's what you need to remember. It's a complex legal concept requiring careful consideration. Be aware of rights and obligations to act appropriately. Timely notice and actions are essential to invoke force majeure provisions. Clause 1.1.6.4 Force majeure in FIDIC contracts is multifaceted and requires careful navigation. Whether you're a novice or an expert, understanding this clause is essential in the complex world of contracts. If you found this video helpful, don't forget to like, subscribe, and share it with your colleagues. For more insights on FIDIC contracts, stay tuned. Now let's move on to next clause.
Moving on to Clause 1.1.6.5, which pertains to laws. This clause provides a comprehensive definition that lays the legal groundwork for the contract. Let's explore what it means. Clause 1.1.6.5 Laws means all national or state legislation, statutes, ordinances and other laws and regulations and bylaws of any legally constituted public authority. What does this mean? The term laws encompasses a wide range of legal instruments, including national and state legislation, statutes, ordinances, regulations, and bylaws. These must be recognized and enforceable by a legally constituted public authority. Why is this important? Understanding and complying with the applicable laws is a critical aspect of any construction project. This includes not only the laws directly related to construction, but also those governing labor practices, safety, environmental protection, and more. For example, in a project involving the construction of a railway line, the contractor must comply with various laws, including construction laws, labor laws, and environmental laws. The definition of laws in the FIDIC Yellow Book 1999 serves as a reminder that construction projects are not just about bricks and mortar. They are complex endeavors that must navigate a web of legal obligations and responsibilities. Understanding and adhering to these laws is not just a legal requirement, but a reflection of ethical practice and professional integrity. In conclusion, Clause 1.1.6.5 Laws in the FIDIC Yellow Book 1999 underscores the importance of legal compliance in construction projects, reflecting the multifaceted nature of the industry. Whether you are a contractor, engineer, or other stakeholder, understanding this clause is essential to ensure that the project proceeds within the bounds of the law, safeguarding the interests of all parties involved. If you found this information valuable, please like, share, and subscribe for more insights into the world of FIDIC contracts. Feel free to leave your comments and questions below, and I'll be happy to engage with you. Now, let's move on to next clause.
Moving on to next clause, performance security is a cornerstone in construction contracts, acting as a protective shield for the employer against potential defaults by the contractor. Under the FIDIC Yellow Book, this clause outlines the requirements for providing security, weaving a legal framework that emphasizes the contractor's obligations. Now, let's delve into a real-world scenario that brings this clause to life. Imagine a construction project in the Middle East. A dispute arose over performance security. The contractor was obliged to provide a bank guarantee as security, but the employer attempted to call on this guarantee due to alleged project delays. The contractor, feeling unjustly accused, contested the claim, leading to arbitration. The arbitrator's examination of the performance security clause and the specific conditions for calling on the guarantee led to a decision in favor of the employer. The contractor's bank was required to honor the guarantee. This case highlights the critical importance of clear and unambiguous terms in the performance security clause. So, what can we learn from this? First, ensuring that the terms of performance security are clear and specific can prevent disputes and misunderstandings. Second, this clause provides a robust legal basis for the employer to seek compensation for non-performance, reinforcing the contractor's obligations. And third, performance security serves as a vital risk mitigation tool, aligning the interests of both parties and promoting accountability. In conclusion, Clause 1.1.6.6 performance security is an essential aspect of FIDIC contracts. It reflects the balance between the employer's need for assurance and the contractor's responsibility to fulfill its obligations. Through real-world examples and case studies, the intricacies and practical applications of this clause become evident. Understanding and effectively implementing performance security can lead to successful project outcomes, minimizing risks, and fostering trust between contracting parties. By delving into the legal nuances and real-world implications, professionals in the field can navigate the complexities of this vital clause, contributing to the overall success and integrity of construction projects. If you found this information valuable, please like, share, and subscribe for more insights into the world of FIDIC contracts. Feel free to leave your comments and questions below, and I'll be happy to engage with you. Now, let's move on to next clause.
Moving on to next clause 1.1.6.7, known as site. This clause defines the places where the permanent works are to be executed, where plant and materials are to be delivered, and any other places specified in the contract as part of the site. Understanding this clause is fundamental as it sets the geographical boundaries within which the contractor will perform the works. The site can include not only the construction area, but also other locations specified in the contract, such as storage areas for materials, facilities for workers, and access routes. The purpose of this clause is to establish a clear understanding of the project's location and the areas where the contractor is responsible for executing the works. This understanding is crucial for many aspects of the project, including logistics, planning, safety, and legal matters. Now, let's explore the implications of this clause. The contractor is typically responsible for the security and safety of the site. If materials are stolen or damaged on the site, the contractor might bear the cost, unless otherwise stated in the contract. The contractor also needs to manage the site to minimize environmental impact, comply with local regulations, and maintain good relations with local communities. Key considerations when interpreting this clause include the exact boundaries of the site, any legal or environmental restrictions related to the site, and responsibilities for utilities, access roads, and site security. In conclusion, Clause 1.1.6.7 site is more than just a physical location. It's a legal and operational concept that plays a vital role in the execution of the contract. The interpretation and implications of this clause can vary depending on the specific circumstances of each project and jurisdiction. Therefore, it's always recommended to seek legal advice when interpreting contract clauses. By defining the site meticulously, all parties can have a clear understanding of their roles, responsibilities, and the boundaries within which the project must operate. It's a foundational aspect that sets the stage for many other elements of the contract. If you found this information valuable, please like, share, and subscribe for more insights into the world of FIDIC contracts. Feel free to leave your comments and questions below, and I'll be happy to engage with you. Now, let's move on to next clause.
Moving on to the term unforeseeable is used in specific subclauses in the FIDIC contracts. These include subclause 4.12, which refers to unforeseeable physical conditions, subclause 8.4, which pertains to unforeseeable shortages in the availability of personnel or goods, and subclause 17.3, which covers unforeseeable operation of forces of nature. The purpose of this clause is to allocate risks between the parties. In principle, the party best able to manage a risk should bear it. However, if neither party can manage a risk, it becomes partially mitigated according to Clause 19. The implications of this clause are significant. For example, if a contractor encounters unforeseeable physical conditions, they may be entitled to an extension of time and additional costs. However, the contractor must have given prior notice of these conditions as soon as practicable. It's important to note that the term unforeseeable does not excuse non-performance. Even if a force majeure event may be foreseeable in the sense of subclause 1.1.6.8, FIDIC excuses non-performance only if the event is beyond the control of the parties, and none of them could reasonably have avoided or overcome it. Contractors should be aware of the potential for unforeseeable circumstances and factor this into their risk management strategies. They should also ensure they comply with any notice requirements in the contract to preserve their rights in the event of unforeseeable circumstances. Consider a construction project where the contractor encounters unforeseen ground conditions, such as unstable soil or hidden underground structures. Under the FIDIC contract, the contractor may be entitled to additional time and cost to manage these unforeseen conditions, provided they have given the necessary notices and can demonstrate that an experienced contractor could not have foreseen these conditions at the time of tender. In conclusion, the unforeseeable clause in the FIDIC contracts is a critical risk allocation provision that can have significant implications for both contractors and employers. It's essential for parties to understand this clause and manage their contractual obligations accordingly. If you found this information valuable, please like, share, and subscribe for more insights into the world of FIDIC contracts. Feel free to leave your comments and questions below, and I'll be happy to engage with you. Now, let's move on to next clause.
Moving on to final clause of this video, in the world of construction contracts, the term variation holds significant importance. Under the FIDIC Yellow Book 1999, Clause 1.1.6.9, variation encompasses a wide array of changes within the scope of a project. These changes include alterations to the quantities, quality, sequence, or timing of the work, omission of work unless carried out by others, and any additional requirements necessary for the permanent works. A variation is not just a simple change, it's either an instruction or an approval. This means that any change falling under the definition of a variation must be formally instructed or approved. It's a process that requires due skill and care, often confined to the engineer to safeguard the employee's entitlement to delayed damages. The variation clause is an extraordinary right. It grants unilateral freedom of scope, but must be used with caution. The contractor is bound to the instructions of the engineer, even if an instruction constitutes a variation. This focus on formal instruction initiates binding effects, potentially leading to financial and other consequences. Avoiding variations starts at the outset. Carefully prepared specifications, bills of quantities, and employees' requirements can prevent ambiguity and discrepancies. Clear and unambiguous contract documents are self-explanatory, reducing the need for support from the engineer. Conversely, unclear documents may lead to misunderstandings and omissions, resulting in instructions that may constitute a variation. In summary, the variation clause is a critical part of the FIDIC contract. It allows for necessary changes to be made to the project while ensuring that both parties are aware of and agree to the changes. It's essential for the smooth execution of the project and to avoid potential disputes or misunderstandings. Variations provide the flexibility to adapt to changes without breaching the contract. Proper communication and documentation are vital, and the engineer plays a crucial role in managing variations, balancing the need for changes with the potential impact on the project.
The variation clause is not just a contractual formality, it's a dynamic tool that reflects the evolving nature of construction projects. By understanding and applying this clause with precision and care, parties can navigate changes efficiently, maintaining the project's integrity and fostering a collaborative and transparent working relationship. This understanding of the variation clause in FIDIC contracts resonates with both novices and experts, providing a comprehensive and engaging overview. It's a subject that goes beyond the pages of a contract, reflecting the real-world challenges and solutions in construction project management. If you found this information valuable, please like, share, and subscribe for more insights into the world of FIDIC contracts. Feel free to leave your comments and questions below, and I'll be happy to engage with you. Thank you for your valuable time, and thanks for tuning into Growth Mindset Company. Until next time, keep building knowledge.